Today, we will focus on a crucial aspect of international law, the peaceful settlement of disputes between states. Disputes are inevitable in the international arena, but international law provides various mechanisms for resolving these conflicts without resorting to force. Today, we will explore these mechanisms, their effectiveness, and their role in maintaining global peace and stability. The spectrum of dispute settlement mechanisms. International law offers a diverse range of dispute settlement mechanisms, each with its own strengths and weaknesses. Diplomatic methods. Negotiation. The most common and direct approach involving discussions and compromises between the disputing parties to reach a mutually acceptable solution. Mediation. A third party, such as a state or international organization, facilitates communication and assists the parties in finding common ground. Conciliation. A more formal process where a neutral third party investigates the dispute and proposes a non-binding solution. Legal methods. Arbitration. A quasi-judicial process where the parties agree to submit their dispute to a neutral tribunal whose decision is binding on the parties. Judicial settlement. Disputes are brought before international courts, such as the International Court of Justice, which issue binding judgments based on international law. Hybrid methods. Fact-finding missions. Neutral experts investigate the facts of a dispute to clarify the issues and facilitate a resolution. Inquiry. A formal investigation of the facts and legal issues surrounding a dispute, typically conducted by an international commission. Choosing the right mechanism. The choice of dispute settlement mechanism depends on various factors, including nature of the dispute. Some disputes are better suited for diplomatic methods, while others require the legal expertise of arbitration or judicial settlement. Relationship between the parties. States with close ties may prefer informal negotiations, while those with strained relations may opt for more formal mechanisms. Resources and time constraints. Arbitration and judicial settlement can be costly and time-consuming, while diplomatic methods may be more expedient. Political will. The success of any dispute settlement mechanism ultimately depends on the willingness of the parties to engage in good faith and abide by the outcome. The role of the United Nations. The United Nations plays a crucial role in promoting peaceful dispute settlement. The UN Charter obliges states to settle their disputes peacefully and provides various mechanisms for achieving this goal. Security Council. Empowered to investigate and recommend solutions for disputes that threaten international peace and security. General Assembly can discuss and make recommendations on any matter within the scope of the UN Charter, including disputes between states. International Court of Justice. The principal judicial organ of the UN, providing advisory opinions and resolving disputes between states. Effectiveness of dispute settlement mechanisms. The effectiveness of dispute settlement mechanisms varies. While some have achieved notable successes, others have faced challenges due to political considerations, resource constraints, or lack of enforcement mechanisms. However, the existence of these mechanisms is essential for maintaining a rule-based international order and providing peaceful avenues for resolving conflicts. The future of dispute settlement. As the world becomes more interconnected, the need for effective dispute settlement mechanisms will only grow. Emerging challenges such as cyber attacks, climate change disputes, and conflicts over resources will require innovative approaches and greater cooperating between states. By embracing and strengthening these mechanisms, the international community can build a more peaceful and prosperous future for all.